Hello everyone, today's video is called Interesting Personal Injury Lawsuits, where I am going to tell you about 11 recent interesting personal injury lawsuits, and I'm also going to give you my commentary on it. So definitely a different kind of video with a fresh kind of take. All right, so the first story is about the unfortunate passing of Kobe Bryant in a helicopter crash, and his widow is suing the helicopter company. So I'm going to read some excerpts from the news story. The news story is from ESPN.com, and it says, Ara Zabayan, pilot in Kobe Bryant crash, might have been disoriented in fog, NTSB says. So it goes on to say that the pilot of the helicopter that crashed in thick fog, killing Kobe Bryant and 7 other passengers, reported the aircraft was ascending when it actually was heading for the ground, federal investigators said in documents released Wednesday. So this is definitely new information. This is probably what led to the cause is he thought he was going up when unfortunately he was going down. So this will play a major role in assessing whether there was negligence or not. You know, if it wasn't because there was a faulty engine or something wrong with the helicopter, then we know they're not going to be able to place blame on the helicopter manufacturer or on the helicopter company for not properly checking the helicopter. All right, so it goes on to say later in the article, 4 current and 1 former pilot for Island Express were interviewed by NTSB investigators, and while some praised the company, others said the safety culture could have been better, according to the reports. So now of course, we get more into negligence. People are saying the safety culture could have been better. So they're implying that there's certain steps that the helicopter could have taken to avert such a disaster. And if they establish that in court, then of course that will help prove their case. Then it goes on to say, one pilot said Zabayan, the company's chief pilot, didn't discuss safety policy or the minimum visibility needed to fly in certain weather. Another comment said the company didn't have a real safety management program. So again, getting into negligence, you know, the helicopter company might say, oh, it's not our fault. You know, the pilot got disoriented. That's not our fault. But the plaintiff, of course, will argue that there should have been some sort of standard of care. And you're going to hear this a lot when you look at personal injury cases. There's a term called standard of care. Standard of care is basically a certain standard that industry sets for a certain company in a certain sector when they do business. So take, for example, the helicopter company. You know, there might be a normal standard in the business that helicopter pilots are trained a certain amount of hours not to get disoriented. So, you know, at a deposition, the plaintiff's attorney might try to find out, you know, were these standards implemented? Did the pilot have the necessary amount of training to try to help him get used to these situations where he wouldn't get disoriented? They might try to find out whether there was some sort of manual or education process that the company required the helicopter pilots to take. And if they didn't follow those steps, then of course they'll be able to prove negligence. So it goes on to say the company, however, said it had no problem canceling flights if weather was poor. It cited 6 flights it canceled for LA Clippers star Kawhi Leonard and 1 for celebrity Kylie Jenner that would have used the same helicopter. Okay, so it says Island Express reported 150 flight cancellations due to weather last year. There were 13 cancellations due to weather for 2020, all logged in the 2 days before Bryant's fatal flight. So here, uh, this will come up as a defense that, yeah, we are careful. We do cancel flights if the need arises. We're not, totally reckless. Okay, so it says the afternoon before the flight, after returning the Bryants and their guests to Orange County, Sabayan had texted that he had just checked the weather for his next flight, and it was not the best day tomorrow, but is not as bad as today. So, here is some evidence that he knew that there might be an issue, which that text will probably be used by the plaintiff to show, yes, you did have notice that there would be an issue. Brian's widow, Vanessa, has sued the pilot, Island Express, and the owner of the craft for negligence. In the lawsuit filed in February, as a star-studded public memorial was held before 20,000 people at Staples Center, where Bryant played most of his career, Vanessa Bryant said the pilot shouldn't have flown in these conditions and should have aborted the flight. So, again, that will be the argument by the plaintiff. You could have taken steps to avert this disaster. Zabayan's brother responded in a court filing that Kobe Bryant knew the risks of helicopter flying and that his survivors aren't entitled to damages from the pilot's estate. Island Express Helicopters has denied responsibility, calling the crash an act of God beyond its control. So again, that will be their argument. It's not our fault. This is something very unusual that happened, and we couldn't have predicted it. Okay, so there you have it. And I'm going to go on to the next news story. All right, so the next story is very timely, and it has to do with the protests that came about as a result of the killing of George Floyd. And apparently a photographer from the media that was at one of the protests got seriously injured. So it says, photographer amid Minneapolis unrest sues, says officers blinded her in eye with non-lethal shot. All right, so this is from the Star Tribune. So lawsuit says her last photo shows Minneapolis police firing at her during the protest. And it goes on to say a journalist who was covering the recent rioting in Minneapolis alleges in a lawsuit that law enforcement blinded her in one eye with a non-lethal projectile fired at her despite her declaring in words and documentation that she was a member of the news media. So it goes on to say Linda Tirato's suit filed last week in the U.S. District Court named as defendants the city of Minneapolis and its police chief, Madaria Arradondo, Lieutenant Robert Kroll in his capacity as head of the city's police union, State Department of Police Safety Commissioner John Harrington, and State Patrol Colonel Matt Langer. So I just want to point out that this is very common legal practice. You see here, she's suing multiple parties. And when you commence a lawsuit, you'll notice sometimes that your attorney will name multiple defendants in the lawsuit. And sometimes you wonder, why do I need to sue 10, 15 different defendants? What's the point? So this is important legal strategy because, sometimes you're not sure exactly who is totally at fault in the case. You could sue one party and at some point they could argue, oh, it wasn't really our fault. It was really another party's fault. And the judge might agree with them and toss the case out. So by including every single possible person that might be have a responsibility in this case, you protect your case because there's something called the statute of limitations, which is there's a limit to how long you can bring a case against someone. So if the judge determines that the defendant is correct and it's really someone else's fault, and the time has passed to bring the lawsuit against that other person, then you just messed up your case. So because of that, it's really important to anticipate who could be potentially liable. Okay, so I'm just going to read some excerpts, and later on in the article it says, protesters led her to a medic before she was taken to a hospital where she awoke from surgery and was told she was permanently blind in her left eye. So it says she was permanently blind. So this goes to the issue of damages. When we're assessing the value of a case, and sometimes even if there is a case, you're looking at how severe the damages are. And one thing is here, it's permanent, so the fact that it's permanent and it's not going to improve, that makes this a fairly serious case, as opposed to someone that says, okay, I got affected, but then 2 weeks later they're totally healed. So that won't be a serious injury, and the value of the case will be far less. And here she can't see in one eye. That's a major injury that you could be assured what they're seeking in damages is quite high. Okay, so it goes on to say, Bruce Gordon, a spokesman for defendants Harrington and Langer, said the State Patrol is unable to discuss the specifics of the litigation. So you'll see this sometimes where the defendant will decline to talk to the media, and that's because sometimes what they say in the public sphere can be used against them in the litigation. So sometimes their attorney will advise them, okay, it's better not to talk to the media because you might not know whether something you'll say will be used against you by the plaintiff to help their case. Okay, so it goes on to say later, Tirado, the mother of a 9- and 7-year-old, has lost some hearing in her left ear from the projectile hitting her in the head, the suit says. So this is, again, a very serious injury. She's losing eyesight. She's also losing hearing. So this will have a major bearing on her quality of life. It also mentions she has a 9- and 7-year-old. So she can't properly take care of them because of it. And it sounds like she's relatively young. She has young children. So that will be a factor in the value of the case. It sounds kind of cold, but unfortunately, in valuing a case, the court will look at the age of a plaintiff. So if someone has many, many more years ahead of them, the value of the case will be higher because, they're able to work for another 30 years, 30, 40 years. So let's figure out what those lost earnings could have been over that time span. And it mentions family members. Now, it's actually typical sometimes. Well, it is common when you have a situation where a family member is affected. Usually it's the spouse, where the spouse will be included as a plaintiff, not just the person that got hurt, but the spouse can also sue, claiming something called loss of services, which basically means I, as a spouse, my life has been directly affected because my spouse is not who he or she used to be. So I want my fear of the damages as well. Okay, so it goes on to say the suit does not specify a dollar amount being sought for Tirado, but it asks for punitive and compensatory damages, along with an order from the court of the defendants to stop using excessive force to stifle coverage of protests. So, this goes into what kind of damages you're going to ask for. There's different legal terms that you could ask for, and this is important. What you're including as damages in the complaint. Here it says punitive and compensatory damages. So these are really important words, because if you're asking for compensatory damages, it's basically saying, give me exactly the money that I lost. So that's all you get, the money that you lost. Punitive damages is basically means you can get far more, than what you lost. It means punish the defendant for what they did. So you're getting a multiple of the damages. So it allows you to recover far greater amount. And here also they're asking for not just money damages, but they're asking for a court order that the defendant stop acting a certain way. All right, so the next article also relates to the protests that resulted from the killing of George Floyd. And it's called Injured Portland Protesters File Lawsuit Against Police Brutality. So it goes on to say, in recent days, 5 protesters in Portland filed lawsuits against the city, arguing that at different times since last May, all 5 were violently attacked by police using military-style weapons while they were peacefully protesting. So it goes on to say the civil lawsuits filed in Multnomah County Circuit Court allege battery and seek damages up to $950,000. In addition, each plaintiff is asking the judge for an injunction prohibiting the police from using weapons that launch projectiles. So I'm just going to take apart this paragraph here. First of all, apparently they're asking for up to a certain amount, $950,000. So it's common practice when a plaintiff is trying to put pressure on the defendant that they will name a amount greater than they actually expect to get. And this is a pressure tactic, because if you're asking for an amount far greater, then you hope that it gives you leverage, and at least the defendant will agree to a percentage of that, as long as your request is not totally outrageous. So, it's common for plaintiffs, especially when negotiating, to ask for maybe three times or maybe 4 times what they actually want to end up with, and hopefully it'll get bargained down to the number that they really expected. Sometimes the plaintiff won't bother naming in the complaint the exact amount that they're seeking. Here they say specifically, we want up to $950,000. A lot of times they will just say in an amount to be determined at trial, because they don't want to box themselves in. What happens if they later realize that the case is worth far more than $950,000? So why limit yourself to that amount? Okay, so also it talks about here, they're asking for something called an injunction. So an injunction is basically a tool that is used besides for asking for money damages. And it means that we're asking for a court order that the defendant stop doing something. In this case, they're asking the court to order the defendant, which is the police, to stop using what they feel is excessive force. So that's alternative to money damages, and it's typical to see the order telling the defendant not to do something as opposed to actively do something, because it's much harder to tell someone to do something than have the court issue order saying you better not act a certain way, because if that's much easier to enforce, because if they don't listen to the order, they could be penalized. So that's important to look out for. Okay, so later on it says in the article, the city is also being sued in federal court by protesters and the group Don't Shoot Portland to block police's use of tear gas, also known as CS gas. So here you see they're mentioning that a party is going to federal court as opposed to state court. And there's a number of reasons why a plaintiff will want to go to federal court as opposed to state court. Sometimes the issue that you're suing about is a federal matter. So you want to be able to sue in federal court. Other times it's for tactical reasons. You might have an issue which you feel is the federal court will be much more favorable to you on this matter. So you'll want to have it switched or originated in federal court as opposed to state court. And so sometimes you'll feel that the federal court might adjudicate, which means carry on the case much quicker than the state court, and you as a plaintiff feel that is a great tactic for you to have the upper hand if the defendant is not able to drag on the case. So this is important to look out. Okay, so later on in the article it says that another protester, so it's naming some of the protesters that were injured. So it says another protester on June 5th, Julia Leggett, was demonstrating when she alleges police, and this is a quote, intentionally launched a flashbang grenade at her right leg as she was walking away from officers. So notice the term intentionally, and this is important because when you're suing, you could sue for negligence. That means they should have been more, the defendant should have been more careful. But you could also argue that it was intentional. And if your arguing was intentional, then it's a little bit different because one, the damages are greater. If the court establishes that the person did it on purpose, you can be sure the damages are higher. On the other hand, it's much harder to prove that something was done on purpose. So it's always better to, at least argue both ways. It was intentional, or in the alternative, it was done negligently. So if the court determines that it wasn't done intentionally, at least if they throw out that argument, you'll still have the argument that it was done negligently. Okay, so, and the article closes by saying, Ms. Leggett continues to experience pain and the injury to her leg has now become infected. At no time during the protest did Ms. Leggett ever act physically aggressive towards anyone. So here it mentions how is she carrying on now, what her damages are. She's experiencing pain, her leg is becoming infected. So, in order to value a case, we have to know how is she feeling? How is this person, this plaintiff, affected by the injury? And at a certain point in a lawsuit, there'll be something called a deposition, which the plaintiff will be sat down and asked a bunch of questions about a lawsuit. And at some point towards the end of the deposition, an important question will be, how has your life been affected? What are activities that you were able to do beforehand that you cannot do now as a result of the accident? Or similarly, what were activities that you were able to do beforehand that you're limited or have difficulty doing now? So this is really determine how your life has been affected. And your attorney will advise you try to be as inclusive as possible. Try to list as many things, obviously truthfully, but try to list as many things as possible, because if you don't complain and you say, okay, it's not so bad, then there goes the value of your case. So that's one time where it pays to complain, and to try to say as many things, obviously say the truth, but say as many things as possible that affect your life. Okay, let's go on to the next article. All right, so the next article relates to Amazon, and it's from jdsupra.com. And it says, Texas federal court rules Amazon can be sued for defective product. And so this relates to something called product, this is what we call a product liability case. And just so you should know, a product liability case is more expensive and it's more complex than if you were to bring a regular, let's say, a regular case where someone tripped on a sidewalk or got into a car crash. Because when you're alleging product liability, what you're really saying is a certain product that was made by the defendant or someone associated with them should have been made a certain way. So because of that, you're going to have to prove that. And in order to prove that it was made in a faulty way, you're going to have to hire experts and pay for those experts who basically testify and say they were supposed to be made a certain way, and they deviated from that standard. Okay, so it goes on to say, recently in McMillan versus Amazon.com, the United States District Court for the Southern District of Texas ruled that Amazon.com could be held liable as a seller under Texas product liability statute for injuries caused by a defective product sold by a third-party vendor on its website. Although the court's analysis is based on Texas law, the decision puts one more chink in Amazon's armor. So basically, before I go into more of the details of the case, I just want to mention that we're touching upon a very important strategy. I would say one of the most important strategies when it comes to bringing lawsuits. And that has to do with where you're bringing a lawsuit. And so there's a term called forum shopping, which is basically trying to find the best possible court that will be favorable to your case. So here, the Texas court seems to be favorable towards the plaintiff's case. And so I'm not sure if it's possible they live in Texas, so that's why they brought it there. But, that was definitely part of the strategy. It's in our favor to bring it in Texas. And maybe even in federal court, federal court might be more favorable. Although they might have been forced to bring it in federal court because that we call If the if the parties are in different jurisdictions, that might force the plaintiff to have to bring in a federal court. On the flip side, the defendants are very weary of where the plaintiffs can sue them, so they'll use a tool. It's very common for companies. If you look closely at the fine print of any contract that you're signing, you'll see something called a forum selection clause. This is incredibly powerful. A forum selection clause basically states where, if you decide to bring a lawsuit against the company, where you're allowed to bring it. So if a company is able to say, okay, we want it to be in a certain state, this will give them a tremendous upper hand, because one, they might know that that state will be favorable to them for a variety of reasons. Also, they might pick that state because it's more convenient for them because they're located there. But it also can give them a tremendous amount of leverage, because if they're located in a certain state and you have to sue them in that state and you're located across the country, that will make it far more difficult for you to bring the lawsuit, and it will definitely make you think twice before suing them if you have to hire a lawyer thousands of miles away. So that's definitely a major tactic when it comes to litigation. All right, so the article goes on to say, in McMillan, the plaintiff Morgan McMillan alleges that a generic Apple TV remote purchased on Amazon caused permanent injuries to her 19-month-old daughter. McMillan's husband ordered the remote from a third-party vendor on Amazon, who is located in China. The battery fell out of the remote and was swallowed by the McMillan's daughter, who suffered permanent damage to her esophagus. So the damages sound fairly significant. They're permanent, and her quality of life is definitely going to be quite affected. Okay, so it goes on to say, McMillan then filed a lawsuit against Amazon and Huzi G for strict liability, negligence, and breach of implied warranties. Huzi G did not respond to the lawsuit. Okay, so before I go on, I just want to point out a couple of things. Firstly, the type of damages that are being asked for is strict liability, negligence, and breach of implied warranties. So these are different types of damages that are being asked for, and it's important to know what type of damages you're going to ask for. This is very, very important, because it's a technical thing, but different damages that you're seeking could allow you different levels of compensation. So, and also could be applicable in different sets of circumstances. So negligence, it might be easier to prove than other things, but it might give you a less amount of damages. Breach of implied warranties is very common in products liability cases, where it's basically saying that when you sold me this thing, it was implied that you would make sure that it worked a certain way, and you breached that obligation. So this is something that you want to stick in a products liability case. Okay, so another thing here is, you see here that the vendor that lived in China did not bother responding. So that brings up another point, which is they decide to sue Amazon and this Chinese vendor. And you can be assured that when they were consulting with their attorney, two things went through the attorney's head. One is, if we sue Amazon, Amazon has deep pockets. they have the money that if we sue them, we could recover the money, which is a major factor when you're suing someone, is how much money do they have. If you have a major case and you're suing someone that's poor, you're not going to be able to win any money from them because they have no money. So because of that, Amazon has a big target on their back. The vendor from China, we have no clue how much money they have. If they might have very little money. So if you sue them, okay, they were included in the lawsuit because they have to be, because you have to include everyone that's potentially liable. But the plaintiff might have very limited expectations from recovering for them. Which brings up another point: is here you see they did not even bother. The Chinese defendant did not even bother responding to the lawsuit, because they are in a different country. We don't even know how much assets they have, and if they have any assets here in America. If they have assets in China, it's even if you do win, it's going to be very hard to chase after them and get that money back. Okay, so it goes on to say, first, Amazon argued that the lawsuit should be dismissed because Amazon is not a seller under Texas product liability statute. Second, Amazon argued that even if it was considered a seller, the plaintiff's claims are barred by the Communications Decency Act. So here, defendants are using an important strategy as they're raising multiple defendants because, just in case the judge strikes down one defense, they're safe. They have another defense that they raised. So it's important legal strategy to raise as many of the defenses that you have. This way you strengthen your defense. The same thing goes for the plaintiff side. When you're bringing a case, you have to raise all the possible arguments in your favor. This way, if the judge throws out, if you bring 5 arguments and 4 get thrown out because the judge says I don't think that's a good argument, you still have the 5th argument that you raised. Okay, so it says Texas product liability statute allows actions for strict liability, negligence, and implied warranties against a manufacturer or seller for recovery of damages out of personal injury, death, or product damage allegedly caused by a defective product. So that's the important statute that defines what exactly is the standard of care. And so the court determined that Amazon was a seller because it was integrally involved and exerted control over the sale of the remote. So this is very important because it raises the scope of Amazon's potential responsibility and liability in the millions of transactions that it does every single day. Up until now, Amazon was able to shift responsibility to all those vendors that sold products on their platform. And it made things much easier for them and much cheaper because they didn't have to worry about being responsible for those products. And now the stakes are raised tremendously because now every single day, all those millions of products that are sold on Amazon might be on the hook to make sure that there's nothing wrong with them. So you could be sure that Amazon is taking this very, very seriously, and they're going to want to limit the fallout from this decision. Okay, so it closes by saying Macmillan is a significant case for subrogating carriers pursuing claims against Amazon for defective products in Texas. Although the analysis regarding whether Amazon is a seller under Texas product liability statute is fact-specific. McMillan suggests that Amazon will be deemed a seller anytime a third party sells a product through the FBA. Okay, so of course it basically sums up what I said, which is this is a really significant case, and Amazon will try to limit its significance by saying that it should not apply in other states, and also it's very fact specific, and other cases shouldn't apply to as many cases as possible because the facts are very specific. So that is what it's arguing here. Okay, we're going to go on to the next article. All right, so the next article is from the Orlando Sentinel, and it says, college athlete sues Disney World, saying he lost a season after being run over by a scooter. So it says, an accident during his Disney World vacation cost a college basketball player his season. A new lawsuit filed against the theme park alleges. So he is arguing how the injury affected his life. You know, it's saying he lost his ability to play, and that goes into the issue of damages. How much has your life been affected? If he were to say, I can't play for the rest of my life, then of course that lawsuit is alleging significant damages. So it says, as David Maynard walked through Hollywood studios, an electric scooter driver approached from behind and ran into him in May 2018, the lawsuit says. All right, so before I read on, I want to point out that the accident happened in May 2018. It's not clear from this article when the lawsuit was commenced, but this is a major factor in lawsuits, probably one of the most significant, which is the timing of your lawsuit. There's something called a statute of limitations, which is probably the strictest rule when it comes to litigation, is the time limit that you have to bring that lawsuit. And so if he started this lawsuit now, that's 2 years later, that might run into, depending on which state you're on, that might run into an issue of whether the time is up lawsuit. It's very state specific. You know, so every single thing that type of thing that you're alleging has different time limits. You know, in New York, for example, certain time limits for negligence can be 3 years. But if you're alleging other things, it could be shorter or longer. So it's very important to watch out for that. And because of that, you know, go to an attorney immediately when you have a case, because you want them to file that lawsuit ASAP. All right, so the crash severed 97% of his left Achilles tendon, which required surgery and extensive physical rehabilitation, the suit says. So this already sounds fairly significant. 97% of his tendon was severed. So that's pretty bad. And he needs surgery, and he needs physical therapy. So when a case is being valued, sometimes it's like a very dry analysis. And one of the benchmarks that the court will look at is what kind of medical treatment did the plaintiff need? You know, very hard to value a case unless you have these benchmarks. So surgery pushes up the value of a case significantly. You know, it's a way for the court to say, oh, okay, we know this is much more serious because the guy needed surgery. So that's something for you to bear in mind if you have a case and you need surgery. Bear in mind that will have a significant effect on the value of the case. All right, so it says Maynard has suffered great pain and anguish in the body and mind, his lawsuit said, which accuses Disney of allowing scooters too close to pedestrians and not properly training the unknown driver of the Disney-owned scooter, among other allegations. So these are what the plaintiff is alleging was done negligently. You know, they're saying, yes, you were negligent because there were things that Disney could have done to prevent this from happening. You could have made rules that said these scooter drivers can't drive too closely, and you could have spent time on training scooter drivers. So yes, there was a standard here which you did not follow. And so it goes on to say, when reached for comment, Disney spokeswoman Andrea Finger said, "This is a matter between two guests, and we will respond to the allegations as appropriate in court." So that's going to be the defendant's defense, which is namely, it's not our fault. You know, it's not our fault that a third party knocked into you. You know, sue them. Don't sue us. So it goes on to say, the lawsuit gives clues where Maynard plays, but doesn't explicitly say which school, other than to reveal that he is a Utah resident who attends college in New York. So that sentence touches upon an interesting thing, which is sometimes you'll read about lawsuits in the newspaper and you'll be like, how does a reporter know about this lawsuit? And what you don't realize is that anytime a lawsuit is filed in court, that information is available to the public. Anybody could see those details. So you have news reporters that basically sift through all the court filings, the recent court filings of the court, to see if there's any interesting news stories. So you might have certain details you don't want to get out to the public. You feel it's confidential. And luckily, there is recourse. There is something you could do to protect yourself, which is if you have a case and either you're a plaintiff or defendant and you don't want that detail to get out to the public, you can ask the judge to seal the records of the lawsuit. You can make something called a motion, which is asking the judge for something. And in this case, you're asking, seal the records. I will be hurt if this gets out to the public. And typically, the parties will agree, the judge will agree, unless there is a very strong public interest in getting those details out to the public. You know, then the judge or the other side might try to fight it, but usually that's not the case. And usually the judge will be very fair about it. Okay, so it says here, scooters pose a complicated challenge for Disney and other theme parks to regulate, since the electronic vehicles carry the same legal protection as wheelchairs. A disabilities advocate told the Sentinel, Disney cannot ban scooters and it's difficult to limit who can drive them. So this brings another important point, which is Disney has every interest in trying to prevent injuries. They're trying, obviously, they don't want people to sue them. But the problem here is that their hands are a little bit tied, because if they make rules saying scooter drivers, which are people that usually have disabilities, can't drive in a certain place, they are exposing themselves to lawsuits by those people with disabilities. that are saying that they're discriminating against them. So they're basically in a rock and a hard place because, yes, they don't want people to get run over by scooters, but on the other hand, they could face significant liability if they try to tell these scooter drivers what to do. They could be sued for disability discrimination. So it goes on to say, her attorney, Eric Elsley, blamed, so this is actually, I'm reading further in the article and names another related lawsuit by someone that got injured in Disney World. And it says about this other person, her attorney, Eric Elsley, blames SeaWorld for not properly training the driver to safely operate the scooter or restricting scooters to certain areas. So this again is the underpinning of these claims for negligence. You could have spent more time on training them, and you could have restricted them. So the question is whether the court will buy into that argument. And it says later, when people visit these parks, they have an expectation and belief the parks are safe and all building codes were complied with. We believe that this was not the case here, and our client was badly injured as a result. Morgan & Morgan attorney Susan Payne said in a statement. So basically, it's saying there was a certain standard of care, certain practice that the defendant should have followed, and they did not follow it. So this actually comes up all the time when you have a lawsuit. Is you'll tell your lawyer the details of the case, and they'll be like, oh, okay, that's not a case. And you'll be like, why? I got really hurt. And your attorney will say, okay, you got hurt, but there's nothing in the fact pattern that will establish that the defendant messed up. They did something wrong. So one of the most important parts of the case is not just showing that you got injured, but showing that the defendant deviated from what they should have done. Okay, so it goes on to say later, the woman said her bones were fragile from a previous injury when she had just taken off a medical boot a week earlier. Now the crash broke her pinky toe and left her bruised, the sheriff's report says. Okay, so this is actually another important point here. She's saying that she had a prior injury to the same area. Such a thing actually helps the defendant a lot because if it comes out that you had a prior injury to the same area, the defendant will argue that most of what you're suffering from is actually from the prior injury. It's not from this current injury. So it's actually very common at a deposition. The plaintiff will be asked by the defense attorney, have you ever injured the same area? And if you say yes, the value of the case will go down because the defendant will now argue, how do I know all that you're suffering from is not really from the first time you got hurt, or mostly from the first time you got hurt. So this is an important thing to know. All right, so the next article is about a lawsuit against Amazon. It's also very timely. It relates to the coronavirus and issues of liability that are popping up, and there's going to be many lawsuits, you could be assured, that are going to pop up that relate to coronavirus. So it says Amazon workers sue over coronavirus allegedly brought home from the warehouse. And this is from Seattle Times. Okay, so a group of Amazon.com warehouse employees sued the online retail giant, contending its working conditions put not only them at risk of contracting the coronavirus, but also their family members, including one who died. So Barbara Chandler, one of 3 workers who filed a lawsuit Wednesday in New York, says she contracted the virus in March at Amazon's Staten Island distribution center, where employees were explicitly or implicitly encouraged to continue attending work and prevented from adequately washing their hands or sanitizing their workstations. Within a month, Chandler's cousin, who she lived with, died after experiencing COVID-19 symptoms, the lawsuit says. The suggestion that working conditions at the facility contributed to a specific third-party death distinguishes Wednesday's lawsuit from other coronavirus-related complaints filed against Amazon in recent months. So this is really interesting because the lawsuit is not because Amazon did something to their employees. Well, it is partially because they did something to employees, but it's also because they indirectly hurt another party who they've never had been in direct contact with. In this case, the family members of those employees. So, and this is an important question, and it will be very important for future lawsuits because, the question is, if you negligently cause someone to get coronavirus, and then they pass it on to a third party, and then maybe a fourth party, a fifth party, can that fourth party or fifth party sue you now? If yes, then the exposure to liability is endless. So, what will the court decide? It's a very important question. If they in fact say a third party can sue you, the defendant, it's opening up a Pandora's box. It's very possible they did mess up and they did hurt the third party, but it really poses a serious question of opening up a Pandora's box and exposing the defendant to basically limitless amount of litigation. Here is also in what I read, it mentions what was the standard of care that the plaintiff was alleging. They're saying that the defendant didn't allow them to properly wash their hands, and so that contributed to the problem, and they pushed the workers to come to work, whether or not they felt well. So that's where the negligence comes in, the allegation of negligence. Okay, so it says later in the article, according to Amazon, more than 150 processes have been updated to protect employees, and the company is spending more than $800 million in the first half of 2020 on coronavirus safety measures. Workers diagnosed with the virus are also being offered additional paid time off, the company has said. So here you see an interesting thing here is Amazon is spending a lot of money, a serious amount of money, $800 million in just 6 months, just to keep their workers safe. So what we're seeing here is, especially with companies that have the resources, they're trying to stay ahead of the ball because we don't know at this point what the standard of care is for protecting workers from coronavirus. This is a relatively new issue. So we don't yet know what a court will determine what you should have done. So because of that, companies like Amazon are willing to spend big money to try to limit the fallout of their exposure to liability by spending a lot of money and hopefully being able to argue, no, we did everything we possibly could to prevent these things. So don't sue us, or if you do sue us, we'll be able to show the court, no, we have gone above and beyond to try to prevent and limit such exposure to these sicknesses. So that's an important point to look at. All right, so it closes by saying, the Staten Island warehouse has been a focus of health and safety complaints since March, when employees mounted the first of a series of walkouts. Amazon terminated the leader of the walkouts saying he violated a company quarantine order. That action spurred denunciations and calls for investigation by officials, including Senator Bernie Sanders and New York Attorney General Letitia James. All right, so this is something, it's not a personal injury lawsuit, but this is another interesting fact that they're throwing in here is that Amazon terminated someone, it terminated someone related to a protest in the warehouse. So just I'll briefly touch. I don't know if this specific issue might expose them to litigation, but a case where a company is firing someone because they're retaliating against someone, an employee for doing something, can open up that company to an employment lawsuit for retaliation. So anytime a company is firing a worker, you know, for retaliation, the retaliation might be an allegation that the employee might allege, and the company should consult with their employment lawyers to make sure they're not opening themselves up to a lawsuit. Okay, I hope that you found these articles interesting, as well as the commentary, and as well as the commentary being enlightening. Okay, have a great day.